All rise. Vous vous levez. Please be seated. Veuillez vous asseoir.
Thank you very much. Welcome back, parties and participants. On this side of the proceedings, I understand that we have lost our connection with Nairobi with the video link. Connection to Nairobi is no longer occurring at this moment. The latest we were informed by the registries that we're looking at checking back in about 20 minutes to see if there is some positive development in that regard. So that is what it would be. We thought this should be on the record anyway. In the meantime, is there any, Mr. Steinberg, when we resume, you said before that you needed 20 minutes or 30 on the outside to complete?
Your Honours, yes, I certainly hope to stick to that. What I can tell you is that, unfortunately for the members of the audience, I need to go through certain names with the witness of persons I cannot mention in public, and I then intend to deal with one or more documents, again, which I can't mention or deal with in public. And for the record, these are in the binder from tabs 57 to 64. It's actually 4 documents. One is a translation of the other, or 4 of them are translations of the other 4. There are certain, I don't intend to go through them all, but there are certain isolated parts of them I wish to ask the witness about. And due to the nature of these documents, Your Honours, it's not something that I can deal with in public session.
To what extent? I noticed that you haven't used the PIS much, and to what extent might it be possible to use PIS in order to reduce the incidence of excluding the public?
Your Honours,
proceedings?
I have not used PIS for a variety of reasons. Firstly, because the evidence of this witness has not gone according to the normal progression of prosecution witnesses. Secondly, because there are the technical difficulties that we can only show one document at a time to the witness. But the third reason which causes me problems now is that the names I wish to traverse with these witnesses are names of persons of interest to the prosecution, but not necessarily names of people that are mentioned by him in his statements and therefore are contained on the PIS. One thing, Your Honours, that we could profitably do to use this time is to deal with the admission of certain documents that the prosecution has already dealt with. This is a matter I was going to do at the end of the testimony, but since we have 20 minutes to spare, it may be that we could profitably use that time to deal with the admission of certain documents I have already referred to. I'm in the court's hands.
So you did mean to tender some documents. You remember that our preference was always to do it at the point of reference to those documents, yes, in order to avoid confusion in future.
Yes. I apologize for that, Your Honour, but as I've said, the progression of this witness's evidence has not gone according to the normal process of leading on a document and then handing it in.
All right, we will then do that. The note passed up to me by the court officer indicates that it seems that the difficulty on the other end of the video link has to do with power supply issues. And at the moment, again, there is no indication when precisely the difficulty might be resolved. Be that as it may, you may proceed with tendering the materials you had in mind.
Thank you, Your Honours. I intend to first request for the admission of the 3 affidavits of the witness that have been referred to during the course of this testimony. I can indicate at this stage that the purpose...
3 affidavits?
Yes, Your Honours. I will refer to them. There is... he has identified 3 affidavits... statements. I see the confusion. The 3 statements of the witness. I will also come to the affidavit. The 3 statements are Ken OTP 01090019, and that is his first statement to the OTP dated the 6th to the 8th of July 2013. Your Honours, I can indicate that for present purposes, the purpose of the admission of this document is limited to the issue of the credibility of this witness. This is a document which has been referred to extensively during the course of his evidence, and should this matter ever come before an appeal court, or any other person trying to make sense of this record will not be able to do so without references to that document. At this stage, the prosecution does not request the document be admitted for the truth of its contents. The prosecution has, however, signaled that it intends to do so in due course. References have been made to Rule 68. As my learned friend for the Sang defense points out, Rule 68.2 refers to the admission of documents relating to witnesses who are not before the court. 68.2d refers to people who have either not testified or, having testified in the past tense, have disavowed material portions of their statement. So, upon my reading of Article 68, or Rule 68.2, this is something which will normally be done after the witness has finished testifying.
Mr. Steinberg, so we do not confuse the issues. You are not now... we're not now dealing with Rule 68, are we?
Not at all, Your Honours. It's simply a question of notice to my learned friend. So they're not under any misapprehension that by requesting the admission at this stage only for the purposes of impeachment, that I'm somehow abandoning what I have previously said about the prosecution's intention to request the admission for the truth of its contents.
All right. Okay, let's leave it at that. We now understand why you mentioned Rule 68.
Yes.
All right.
So that is the first statement that the witness was shown and confirmed he made that statement. The second statement was...
let's take it one at a time. Defense counsel.
Yes. Sorry, before the defense counsel stands up, I beg your pardon. For the record, it's I've read out the ERN number, but it's R01, so it's the redacted version that I requested to be admitted.
And that is the document appearing at tab
1, Your Honour.
Tab 1. Counsel, for the defense. Mr. Khan.
I'm grateful, Mr. President. We object for at least a couple of reasons. I'm not going to get into the Rule 68. My learned friend in filings and in other submissions has indicated that that's something that the prosecution think may be relevant to this case. The bench has informed them when they were given an opportunity that that was a matter that they may wish to have clarification on. And, Your Honours, when we started entering a discussion on Rule 68, my learned friend said he wanted to put in submissions at a later stage. So, Your Honours, I'm not going to deal with that. Our concerns in reference to the statute and undertakings given by the ASP have been previously mentioned. That rule is simply inapplicable. Your Honour, the reason we say it's not, it shouldn't be exhibited is for 2 reasons. Firstly, my learned friend was given licence to cross-examine the witness, and extracts that he thought were relevant were read into the record. and those extracts, those paragraphs of the statement are already in the record, it's important to note that the witness was not taken through paragraph by paragraph in relation to each and every aspect of the statement. But, Your Honour, be that as it may, regardless of that point, we say it will be sufficient to assist an appeals chamber or Your Honours, firstly, when you're reviewing the transcript, if that statement, and it applies to all of them, are simply marked for identification. Your Honour, that would allow the transcript to be understood fully. It's particularly important because when one wades through an exhibit list, I don't want there to be confusion. My learned friend has given an undertaking that the prosecution is not seeking to exhibit this statement or any of the other three for the truth of their purported contents. But and that's quite right, and I think that was the correct position. But, Your Honours, in circumstances where a witness has not only resiled from a statement, but said under oath, under pain of punishment, that statement is materially unreliable and is a fiction, a fabrication, because the witness wanted to gain a luxurious lifestyle, in our respectful submission, the court should be very slow to find that such a statement has sufficient indicia of reliability so as to be given an exhibit number. We say it can be properly dealt with by marking it for identification at this point. That will allow the transcript to be fully understood and the proceedings to be rendered intelligible.
Mr. Ken, does that argument you've just made, how far do we take it? Does it go as far as to say that every document that we've admitted on the record is reliable and upon which the chamber must find accordingly?
Your Honour, of course not. But my understanding, at least, and of course I may be wrong, is when when a document is exhibited, the trial chamber have a complete discretion when weighing the evidence at whatever stage of proceedings to determine any fact in issue. The bench may give that statement such weight as they think necessary and appropriate, or may completely disregard it as being unreliable. Given that the prosecution's avowed contention is not to invite the chamber to accept that evidence for the truth of its contents at this stage, we say the purpose of the prosecution and the only basis was to render the proceedings intelligible. That is properly met with the normal reservations by marking it for identification. If and when we get to a stage where the prosecution seek to use any other provision of the statute, that matter, of course, can be revisited. There is a record, of course, in the proceedings that may provide a basis. The law can be argued and the bench can dispose of the matter. But given the purpose, the narrow purpose, that my learned friend, when given an opportunity, has adumbrated, we say it should be marked for identification so that when we're looking through the exhibit list at the end of the day, and I've seen prosecution exhibit lists, it doesn't have an annotation, not for the truth of its contents. Given that, marked for identification is sufficient.
What's your... the witness has, in terms of reliability, that surely depends on the context of the discussion, that discussion on reliability. If it is a document that came out and no one knows where it came from, counsel says, well, we don't want that thing on the record because it has not been authenticated. That's one thing. But here we have the witness who says, yes, I made that statement. But what I'm saying is that part of that are false and parts are true. And we've gone through the extent of the material that the witness says is false and those he says are true. And they're quite extensive. Does it not make more sense then to, in light of the extensive nature of those references, to bring the document in, knowing what the witness has said about the truth of the content?
Well, Your Honour, I take the point, and it's well put, if I may say so. But in our respectful submission, the primary evidence that Your Honours must consider is the evidence under oath. And the transcript that the court stenographers assiduously prepare is the record that should be the first port of call. And that record will include both the cross-examination of the prosecution of their witness, as well as attempts by the prosecution to controvert that account or impugn the credibility of the witness by way of a previous statement. So, Your Honour, all that's in the record already. So the only purpose of the previous inconsistent statement that the witness has recanted and said is a pack of lies, in large part, is to understand the transcript. If that is the limited purpose, we say, for the sake of clarity, it should be simply marked for identification. That way it can be used. It's part of your court record. It can be used to render the transcript intelligible, but it would avoid any confusion by the prosecution or any of us that it is accepted that it can be admitted for the truth of its contents. And indeed, the prosecution are not seeking it, which in our respectful submission militates in favour of marking it for identification. Otherwise, Your Honours, why mark anything for identification? The reason you seek to exhibit principally is because we say it is relevant to a fact in issue and it can be taken for the truth of its contents. The prosecution are not, so we say marking it for identification renders the transcript intelligible and meets the requirements of certainty and clarity that would be welcomed by all parties, I'm sure. Your Honor, those are my submissions on the matter.
Thank you very much. Mr. Kigen-Katwa, quickly.
Your Honor, we take the same position as submitted by the Ruto team. And Your Honor, our understanding of what the prosecution desire is to make the record complete and for purposes of clarity. We submit, Your Honor, that by marking the document for identification, those two criteria are satisfied. Your Honors will recall that on our part we volunteered that the prosecution can read verbatim what they need from the statement and cross-examine the witness on them so that whatever they are interested in from the initial statement can be brought out. It is our submission that that was done exhaustively and that the attempt now to introduce the statement, especially considering that the statement was not read 100%, would be unfair. For those reasons, Your Honor, we submit that the statement should be marked for identification.
Mr. Steinberg, the argument is that if the only reason you want to tender material is to make the record intelligible, your learned friends are saying that you can do that by marking the document for identification. Can you address that matter?
Yes, Your Honours. The purpose, as I understand, of marking a document for identification is where a document is shown to a witness, a document which has not yet been properly established, the provenance or the authenticity, is shown to a witness for his comment, subject to subsequent proof. In other words, if I wish to show in cross-examination of a defence witness a document produced by one of my investigators, I can show it to him and then say, I will call the investigator in rebuttal to prove this document, but for that limited purpose, it's marked for identification. The purpose here is completely different. The witness has already identified the document. He's confirmed that it is a statement he gave to the investigators. He's confirmed his signature on the document. So on the normal requirement of a showing of a proper or a reasonable connection between the witness and the document, my respectful submission is that that requirement has easily been met. My learned friend raises the issue of reliability, that there's no indicia of reliability of the document. But with respect, Your Honours, in the present circumstances, that's a complete red herring. The reliability of the document is only relevant if the party seeking to tender it wishes to rely on the correctness and the truth of its contents, which we're not seeking to do. I honestly don't understand the basis of the objection. Where my learned friends say I could have read the entire document verbatim, which would have taken us probably a good day of court time, into the record, they would have had no objection. But instead, because I followed a more, in my submission, efficient technique and only put to the witness those parts which I deemed to be the most necessary to put to him, that therefore the rest of it should fall out. In my respectful submission, the document itself, everything about the document, everything it contains, and the juxtaposition of this document versus the affidavit which the witness subsequently attested to is relevant to the issue of whether or not the witness's recantation is credible or not. If this witness's recantation is accepted, let's not beat around the bush. It is very damaging, or would be very damaging, to the prosecution case. If this chamber were to accept for a moment that there was a possibility, a reasonable possibility, that prosecution investigators were supporting perjury, that is a matter which the prosecution takes very seriously. But in my respectful submission, taking into account the witness's evidence to date, and I'm not quite finished yet, but the evidence already on record, as well as the documents before the chamber, this is the only way on which the chamber can reach an informed decision. And on the point of marking for identification, my understanding of the situation is if a document is simply MFI'd, it does not form part of the record. It is therefore not, or if the matter were to go on appeal, the normal processes on appeal is that an appeal chamber is bound by the four corners of the record. That is the traditional position, and I don't believe it's different here. So unless the documents are admitted as evidence, the appeals chamber would not have sight of those. Now, I don't see how there can be any confusion as to the purpose for which is admitted. My learned friend has said the record is, the transcript is a record of the case, the authoritative record in the case, and it's there in the transcript. Those are my submissions, Your Honor.
Sí.
The objection is overruled. The document will be admitted onto the record. The witness clearly identified the document as a statement that he had made, and the prosecutor made extensive references to aspects of that document, so much so that if there was any harm to be done in admitting the document, it might have been done already. So at this stage, we might as well admit the document. So the document comes in.
I'm grateful.
The document will be marked as the next in the prosecution exhibit.
The document KenyaMOJA.com 01090019 R01 confidential will bear the number EVD T OTP 00132.
Mr. Steinberg, your next document.
Thank you, Your Honours. The next document is one which is connected to the first one, and that is the witness's statement of the 14th of July 2013, where he handed to the investigators the two diaries. The reference is KenOTP 01090071 R01. Your Honours, the witness also identified this
Tab, please.
I beg your pardon, tab 21. The document has the witness has also identified this document as being an affidavit he attested to the investigators. He's confirmed his signature.
You mean statement?
Statement, I mean.
There's a difference between statement and affidavit.
Yes, I'm sorry, Your Honours, where I come from, all statements are taken as affidavits, so I'm afraid it's hard to unlearn 25 years of habits. the statement. And in connection with that, also the two diaries to which we've referred to, and those are KenOTP 01090082 and 0157 respectively, and they are the following two tabs, 22 and 23. They're not redacted.
So the two diaries they come with the statement.
They are, in fact,
annexes to the statement.
they're annexes 1 and 2 to the statement, and in fact the statement, the purpose of the statement is to hand over and explain the diaries.
Mr. Cannon?
No objections, Your Honour.
Mr. Keegan-Cardwell?
We will not object, Your Honor. We are not objecting.
The documents would be admitted as the next in the prosecution exhibits.
Your Honour, in relation to the statements, and I think my learned friend's undertaking that there's no attempt at the moment, at the time of exhibiting these documents, for them to be used for the truth of their contents. That applies in relation to all of the statements. So with that undertaking, no objection.
Yes, that was an omission on my part. I confirm that.
That was the understanding that the prosecutor confirms that. Court officer, please.
One moment, Mr. President. I apologize. The document KEN OTP 01090071 R01 confidential will bear the number AVD T OTP 00133. The document KEN OTP 01090082 confidential will bear the number EVD T OTP 00134. The document KEN OTP 01090057 will bear the number EVD T OTP 00135.
Is that Mrs. Steinberg, I understand that the second diary would be 0157, is that it?
Correct, Your Honours. 01090157.
So that should be the second annexure to the last step.
Yes, Your Honour.
Statement. All right. The record will stand corrected. So it should be where we now have 0057 should be 0157.
Correct, Your Honours. That's at line 22 of page 100. The correction should be made.
Proceed, Mr. Steinberg.
Thank you. The third statement the prosecution wishes to exhibit is the statement of the 13th of November 2013. It is Ken OTP 0117 1019 R02. That's a redacted version. It is at tab 38. Your Honours, again, this is a statement tendered for present purposes only for impeachment. not for the truth of its contents. Again, the witness has identified the document, the statement confirmed that he signed it, and I submit that for the same reasons as the previous two statements, this one should also be admitted.
Mr. Khan?
No objections, Your Honour.
Mr. Keegan-Katwa?
Your Honor, we object based on the same grounds you had raised, that the important aspects of that statement that had been intended to be contested by the prosecution have already been read into the record.
Mr. Keegan-Katwa's objection is overruled. The document is admitted as the next in the prosecution exhibit.
The document KEN OTP 01171019 R02 confidential will bear the number EVD T OTP 00136. And I take this opportunity to correct the record to say that the document KEN OTP 0109 0157 is the document that will bear the EVD number EVD T OTP 00135. Thank you.
Thank you. Mr. Steinberg?
Thank you, Your Honours. The next document which I would request to be exhibited is the investigator's report at tab 65. The ERN is KEN OTP 01380501, and the basis in R01, I beg your pardon, R01, tab 65. It's an investigator's report dated 18 July 2014, and this is the report dealing with the SMS sent by the witness to the field office as conveyed to the staff. Your Honours, my submission is that the substance of this investigator's report was confirmed by the witness, and I refer to real-time transcript 132, that's this morning's transcript, page 12, lines 4 to 12, where this issue is dealt with. The witness confirms at lines 11 or 12, after I read the message out, that he remembered sending such a message. And, if I understand correctly, confirms also the subsequent conversation with the OTP member. So on that basis, I submit that the document has been sufficiently identified and confirmed by the witness to warrant admission as an exhibit.
Mr. President, objection in relation to this. My learned friend, in our respectful submission, the prosecution cannot circumvent the principle of orality in this manner. We have an investigator's note. The witness denied sending an SMS. We don't know who the OTP representative is. We were told some unknown person in a field office, but no record was kept by the prosecution of that SMS to give it to the defence. And in the circumstances, the testimony to the witness on that point will speak for itself, but the prosecution must be constrained, we say, to the basic rules that evidence must be relevant to a fact in issue, and this investigator's report prepared by the named individual should not be exhibited in the present circumstances. So the objection is there.
Your Honour, we equally object on the same grounds, but in addition, Your Honour, we observed that the document had not been disclosed to the defence, and secondly, that it meets accurately the criteria that the prosecution had made out for marking for identification, being that a document is marked for identification for subsequent identification by the party who was involved in its making, and we submit that the investigator who composed the report should be the one to come and identify it, and possibly an effort can be made at that point to produce it.
Thank you. Your Honours, firstly, the witness did confirm sending the SMS, and I'll read it out because this is the second time my learned friend has said that he didn't. I'm reading from page 12 of the record. I read from line 4. I put it to the witness that on the 18th of August he sent an SMS to a member of the field office, reading as follows. I then read the message out. I ask the witness, do you remember sending such a message? And at line 12 he unequivocally says, yes. And is it correct that the person you wanted to speak to then called you back and you told him that you saw on the internet that you had been summoned? Is that right? Yes, I told him I saw, it should be, I think, in the paper and the paper. So
I don't want to interrupt my learned friend unnecessarily, but there's obvious difference. 18th of August is what the transcript says, and the document he seeks to exhibit is 18th of July.
Your Honours, perhaps that is something I should clear up with the witness first, and that was an error on my part. But clearly, the witness has confirmed sending the message and confirmed the contents and the relevant portions of this investigator's report. Now, it is true that the prosecution could at some stage call an investigator to come and testify to this. But if the prosecution is constrained to call witnesses to come and testify to each and every item of information put before the court, this case will never end. My learned friend has repeatedly asserted his client's right to a speedy trial. The Chamber has a discretion to admit evidence of this nature, in particular where it is evidence which does not deal with the acts and circumstances of the accused. This is a purely procedural matter. It is a record which is kept in the ordinary course, and it is a contemporaneous note of this conversation. And in itself it has indicia of reliability, over and above the fact that the witness has, in my submission, confirmed the contents.
The objection is sustained. Mr. Steinbach, do you want to mark it for identification?
Please, Your Honour, I would like to mark it for identification. Just one other issue of clarification. I can confirm that the relevant investigator's report was disclosed to the defence on the 21st of August 2014. It's in fact one of the documents included in the Regulation 35 request, which the Chamber approved recently.
The document will be marked as the next document for identification on the part of the prosecutor.
The document KenyaMOJA.com 01380501 R01 confidential will bear the number MFI T OTP 00137.
Your Honour, the last document, well, no, the second last document I wish to seek to deal with at the moment is the screening note of the 27th of June 2013. The reference is Ken OTP 01060965. I had intended to ask for the admission of this document on the basis that the witness confirmed that there was such a screening, but tab 3434.
Yes, proceed.
I on the basis that the witness identified it, on the basis that it is, again, a contemporaneous record. The metadata of this document will show that it was registered on the 1st of July, that is some 6 days before the witness gave his first statement. And on the same basis as the previous one, I would ask for admission. Should the Chamber not wish to admit the document, I ask in the alternative that it be MFI'd.
Your Honour, objection on both heads, in fact. The record speaks for itself, but certainly it was my recollection that the witness did not, when he went through the screening note with my learned friend, he didn't recall the contents of the screening note at all. Your Honour, in those circumstances, it can't assist the Chamber much, but I'm a little bit concerned that the prosecution say that metadata prepared by a party to litigation has some evidential value. That's a novel, surprising and weak argument, we say, that the metadata created by a party to proceedings somehow renders a document admissible. So I'd say that it shouldn't be exhibited, obviously we say, but even to have it marked for identification in the present circumstances, it's not identified. So how on earth can it be marked?
Your Honor, we also object to the production as an exhibit of these screening notes, in part because it was not made by the witness, and the witness did not identify the document, and the prosecution has the window to have it exhibited through the investigator who composed the report.
Your Honours, firstly, may I make a correction? At page 106, line 1, I gave the ERN as 01060105. In fact, the last 4 digits should be 0965. I may firstly make that correction. Your Honours, as regards the MFIing of the document, it's not a case, as I understand it, that the witness has to identify the document. If the witness were to identify the document, normally it would be admitted. The point is to identify the document as a document which has been shown to the witness, subject to subsequent proof if necessary.
Thank you. The document will be marked for identification.
Thank you, Your Honours. The final document...
The document KenyaMOJA.com 0106 0965 will bear the number MFI T OTP 00138. The document is confidential.
Mrs. Steinberg.
Thank you, Your Honour. The last document I wish at this stage to request to be admitted, and I will deal in a moment with the doctor's certificate, but the document I wish to seek to admit at this stage is the affidavit of the witness, dated the 11th of August 2014. It's at tab 68, and the reference is Ken OTP 01351135. And on the same basis, Your Honours, as the other 3 statements, not for proof of its contents, but for the purposes only of impeachment.
Mr. Khan?
On that basis, no objection. I'm grateful.
No objection?
Indeed, no objection.
Mr. Keegan-Katwa?
We do not oppose, Your Honours.
The document comes in as a next in the prosecution exhibit.
The document KenyaMOJA.com 01351135, confidential, will bear the number EVD T OTP 00139.
Thank you, Your Honours. Finally, I wish to deal with one document which is not a prosecution exhibit.
Mr. Stand by 1 second. Just so we're clear on the record, it just occurred to me that the ERN number you indicated, which ends with 1135, is in fact the lawyer's letter, under the cover of which the affidavit was communicated. The affidavit itself appearing at ERN that ends with 1137. And we also have another document at 1140. The intent, of course, was you spoke to the affidavit, and that comes in, so that is intent. But do you also wish the accompanying documents, including the lawyer's letter, to come in as well?
Your Honours, the witness certainly confirmed the last handwritten document at 1140. So yes, I would certainly ask for that goes in on the same basis, also not for the proof of its content. Your Honour, I didn't specifically show the witness the covering email, but I believe it's on record that the affidavit, the recanting affidavit, was forwarded to the OTP by this lawyer.
So we are on the same, we're speaking the same language. This doesn't look to me like an email. It looks like a letter written by Kipsang and Mutai advocates under the cover of their, under their letterhead, appearing in red or orange, as the case may be.
Your Honour, I spoke imprecisely. This letter was emailed, put it this way, the affidavit was emailed to the prosecution under cover of this letter as an attachment. So this is not the email, but this is the document which we received by email. We disclosed it as such to the defence, and unfortunately it has been registered as one document. So if only one or other is to go in, we would have to then re-register it, I understand it, under separate ERNs. Alternatively, if the Chamber is not satisfied that the entire document should go in, which I should submit it should, because it goes to the surrounding circumstances. But if not, then the Chamber could simply make an order that only certain pages are admitted onto the record.
All right. The point that I make is not to express doubt as to whether the sandwiching documents sandwiching the affidavit should not come in. It's just I pointed out so that we have clarity on the record. And you've now made it clear that you want the three documents to come in. I take it you have no objection, Mr. Cannon?
No objection for the affidavit, the handwritten note, and also the first document, the letter from the lawyers, all to be exhibited under the same ARN sequence.
All right. And Mr. Kinkatwa?
We have no objection, Your Honor.
So in that case, the three documents will come in under the same ID number, court officer. There is no need for you to rework your record. Thank you.
Thank you, Your Honours. The final document is the doctor's certificate, which was produced by Mr. Mutai on behalf of the witness, and which was sent to the Chamber via the registry, if I'm not mistaken. This is the doctor's certificate dated the 27th of August 2014. I did make reference to this medical certificate in the course of my questioning of the witness. He confirmed portions of it relating to his financial situation, for instance. And for the completeness of the record, I submit that this document should also be exhibited. Again, not for the truth of its contents, but simply as a document which was put to the witness and on which he commented. And confirmed. He confirmed that this was in fact the medical certificate he obtained.
Mr. Khan?
No objections, Your Honour.
Mr. Kinkatwa?
We do not object, Your Honor.
The document then is admitted as the next in the prosecution exhibits.
Mr. Steinberg, could you please repeat the ERN number of that last document?
That is something I omitted to deal with. This document, of course, does not have an ERN because it was a document which has been submitted via the registry to the Chamber, so it's not a prosecution exhibit. So I would request that CMS assign to it an ERN, or is it necessary for the prosecution to do that? Perhaps I could be guided.
The prosecution should attribute an ERN number to the document a posteriori. We will provide you with an EVD number right now.
I'm happy to do that, Your Honour, if the Chamber is happy with that arrangement. Your Honours, my support team has overtaken me. I understand that, in fact, an ERN number has been assigned, so I can provide that immediately.
All right, that solves the problem there.
Is that a 1 or a 2? 1. 0, 1, 4.